Welcome to the American Society of International Law annual meeting. This is the New Voices panel. My name is Mohammed Hilal. I'm an associate professor of law at the Moritz College of Law at The Ohio State University, also a member of the Permanent Court of Arbitration in The Hague, and it is my pleasure and privilege to be here today to moderate a panel with three spectacular scholars who have three really wonderful papers that they're going to be presenting. We're going to start off with Yulia Emtseva, who's going to be presenting a paper titled Philanthropic Justice, the Role of Private Foundations in Transnational Justice. And then we're going to move on to Mara Rivkin, who's going to present a paper titled Insurgent Legality. And then finally, we're going to have Aaron Wu with a paper titled Sustaining International Law, History, Nature, and the Politics of Global Ordering. So it's a spectacular lineup for you, and hopefully we're going to have a great discussion. So Yulia, you're up first. Over to you.
Thank you, Professor Hilal. Good afternoon, or maybe good morning, or even evening, everyone. Thank you all very much for joining this session and for your interest in today's topics, including mine. As Professor Hilal said, my name is Yulia Emtseva, and the paper I'm presenting today titled Philanthropic Justice, where I explore the role of private foundations in transitional justice processes. The paper is a part of my PhD project, where I focus on a wider range of private actors in the field of transitional justice, but for today's events, I chose to focus only on philanthropic foundations. As the topic suggests, I will speak about transitional justice processes. However, I'm implying that most of you are familiar with the field. I will not explain it in details. I will just point that I look at mechanisms like criminal trials, truth commissions, and reparation programs. During the next 9 minutes, I will try to give you an overview of the activities of philanthropic foundations in the field of transitional justice, and then proceed with my analysis. And my analysis begins with concerns linked to this philanthropic engagement in such sensitive processes as criminal trials or truth-seeking. And I will then look at how the UN, as a principal actor in many transitional justice initiatives, deals with cooperation with philanthropists. And finally, I will offer a glimpse at how international law could contribute to a better regulation of such philanthropic assistance in the field of justice. As I mentioned, I would first like to bring a few examples which actually triggered my interest in this topic. And last year, while thinking about my PhD project, I stumbled across the Peace, and Security Funding Index, where I learned that in 2018, $129 million of private funds were spent on financing transitional justice efforts. And the biggest chunk of this sum was provided actually by philanthropic foundations. And just to clarify, philanthropic foundations can be different in nature and they have different financial models, but it is important to remember that most of the times they're private entities. Moving to more concrete examples, the financial statement of the extraordinary chambers in the courts of Cambodia show that open society foundations, the largest philanthropic organization, one of the largest philanthropic organizations in the world, regularly donates money to the tribunal. And the same activity can be seen for instance, also in the annual financial reports of the Special Court for Sierra Leone, which also accepts financial support and expert assistance from different philanthropies like Oak Foundation, MacArthur Foundation, and some others. With respect to truth-seeking, for instance, the Ugandan Truth Commission repeatedly ran out of money and had to switch offices, let go staff members, and as a result had to cease operations several times. The Commission, however, finally concluded or delivered its final report after the Ford Foundation pledged $100,000, which were actually crucial for the Commission to finish its mandate. Reparations in their various forms have also become of significant interest to philanthropies. For instance, in the US, after the demands for transitional justice as a result of the Black Lives Matter movement, the Andrew Mellon Foundation, the largest humanities philanthropy in the United States, initiated a memorialization program. Memorization is one form of non-material reparations, and the foundation pledged to spend $250 million on the program that will build new memorials and museums and reconstruct or remove some that already exist. As we see, there are many examples of philanthropic assistance to transitional justice mechanisms, and this example embeds most certainly a lot of positive aspects. But in my view, this assistance might also pose some risks because these actors were not meant to regulate such sensitive processes. They were also not designed to tackle underlying structures that led to gross human rights violations. And philanthropic actors often highlight their lack of fear to lose money, and thus they can take these risks and invest in projects that might fail. However, exactly this absence of fear to fail, this market can result in arbitrariness of their actions because they have nobody to be accountable to. To summarize using words of Philip Alston, philanthropic giving is not necessarily a democratic or transparent process. And for these reasons, I decided to delve in the legal analysis of this enterprise from the perspective of international law, because I anticipated that due to the sensitivity of political transitions, and since the basis for initiating transitional justice is actually international crimes, international law would offer some guidelines for the input of private access in such processes. However, I quickly realized that international law is more. To start my business, in the early 2000s, the United Nations established the Office for Partnerships, which grew out of years of collaborations with the Turners UN Foundation. This foundation is a private entity which was created to deal specifically with the Turners' $1 billion gifts to the United Nations to support of its projects and operations. But apart from this Office for Partnerships, the UN has also the Fund for International Partnerships. And these two bodies share a lot of common tasks, and it's hard to differentiate between their mandates, at least for me as an outsider. However, despite the amounts of money circulating between the UN and its partners, decision-making seems to be rather informal. And therefore, it is unclear on which basis and under which guiding standards the UN to support or decides to cooperate with a private entity when it comes to all sorts of public issues, including justice and peace. One of the most disturbing problems is that the absence of clear guidelines as well as accountability and oversight mechanisms opens the possibility for agenda distortion. For instance, according to the annual report of the Fund for International Partnerships, all projects and activities of the UN sponsored by the Turners Foundation had to be in conformity with the Foundation's strategic objectives. And Mary and Glendon expressed her view by saying that Turner's $1 billion endowment to the UN looks less like a gift and more like a takeover bid aimed at UN agencies with privileged access to vulnerable populations. In my paper, I also looked into two different UN internal documents, the guidelines on the principle-based approach to cooperation with the United Nations and the business sector, and the framework for engagement with non-state actors, which is used by the WHO. but unfortunately, due to the time limit, I will just mention that this document, according to the UN staff members, proved to be not very effective. So if there are no strong regulation, even on the UN level, the burning question for me was, if there is nothing to regulate, maybe international law can forbid private involvement in justice initiatives. To get closer to this answer, I turned to the discussion on the privatization of public functions. And unfortunately, the time does not allow me to elaborate on it, but I will briefly say that de lege ferenda, international law, largely tolerates various forms of privatization, and no rule of customary international law can be found to speak against outsourcing state functions. So if there is not much to control philanthropies in engaging in public services, how can international law be used to facilitate the way to a more transparent philanthropic justice? Although in my paper, I leave this discussion open for the future. I leave this section open for the future discussion. I suggested that some already existing mechanisms on regulation of private funds can be used while thinking about the potential international standards for philanthropic justice. And for instance, the Development Assistance Committee of the OECD set some important standards that could be used for the future elaborations on such regulations. And as a final thought, I would like to mention that these initiatives to establish the standards of regulation of philanthropic justice should come from all actors, namely states, international organizations like the UN, and of course, philanthropic foundations. And let me end by saying that my main argument was not that the philanthropic sector's embeddedness in transitional justice mechanisms is a negative consequence of maybe a globalization or it destroys the notion of justice. So, but keeping all criticism in mind, I argue that such partnerships can bring about justice and peace to affected societies, but their proper regulation under international law will only increase the efficiency and positive impact of philanthropic efforts to support liberal democratic development in post-conflict and post-authoritarian countries. Thank you so much for your attention.
Thank you, Julia. This is absolutely fabulous. I learned a lot from this project. I personally was not aware that institutions like Open Society and other philanthropies were so deeply involved in transitional justice processes. But I mean, let me ask you a direct and frank question. I think after reading your paper, I was I found myself asking, but what exactly is the problem? I mean, has the involvement of these private entities in transitional justice process, has it had a deleterious effect on these processes? Have there been any unintended consequences? Has it in any way or form affected the outcome of these transitional justice processes? And I asked that to basically, put that question out there. What would be the purpose of this regulation? I mean, it appears to me from your paper that the purpose is, to increase transparency, ensure that there's a normative architecture to hold these entities responsible. But I guess my question is, responsible for what? I mean, have you found in your research any kind of pattern of abuse? For instance, any in some way or form that they have negatively affected the process of transitional justice? Because from your narrative, it appears that it's a story of success. And so why would we sort of spend the political capital? I mean, and I say we here, all of those actors that you identified, international organizations, states, and those private actors, why would they spend the time, resources, and political capital to draw up a body of norms, say, something like a set of guiding principles, if there's no clear articulation of how have these institutions affected the process of transitional justice? And perhaps connected to that, has there been any conditionality, right? Have these private actors, have these donors involved themselves in these processes in a way that also involves conditionality? In the sense, have they said, well, our money comes with certain conditions. If you're going to take our money and sort of set up a truth and reconciliation commission or a commission of inquiry, this is what you need to do to take our money. And have they involved themselves in any kind of way in the actual management of these processes that leads to some kind of unintended consequences or sort of negative effects on the process? But congratulations on a wonderful project.
Thank you so much, Professor Helal. Do you want me to answer the questions now, or maybe we can listen to the questions of Mara and Aaron, and then if I have time, I will respond.
It's we are here to help you and to have a good conversation. So really, if you'd like to hear Aaron and Mara's thoughts first, we can do that.
I think it would make better sense, at least for me, not to lose time of me explaining again what I meant.
Yeah, sure. Yeah, so go ahead, Mara.
Hey, thank you so much, Julia. This was really fascinating work, and I learned a lot. I had a follow-up question similar to Professor Hilal's about the unintended consequences. And you mentioned in the draft that sort of that one of the problems with private actors, sort of partnerships and involvement in these transitional justice processes is that they can sort of interfere with the priorities of the national government, or sort of interfere with the priorities of the state and its agenda. And and thinking about what these, some of the consequences of that might be, there's a big political science literature on kind of the negative unintended consequences of prioritizing certain groups of victims over others. And in some of my own work in Iraq, I've seen this where foundations and private actors have directed a disproportionate amount of assistance to certain religious minority groups, particularly Christians and Yazidis, after the atrocities they experienced by the Islamic State, but have directed less assistance to the Muslim majority population and other ethnic minorities. And this has actually directly contributed to some conflicts on the ground where, the Reconstruction, a Christian community is being rebuilt, but it's right next door to a village, another, ethnic group's village that is still completely destroyed. And that creates a lot of resentment and tensions on the ground that can then sort of increase the likelihood of future conflict and intergroup violence. So I think that might be potentially prioritization and of certain victims over others might be an area to explore. And I was just wondering if you'd seen any other examples like that in your own work.
Aaron, do you want to add something, or can I proceed?
Yes, actually, thanks, Julia. I have to say congratulations again from me, from my side. A wonderful paper, extremely detailed, very thoroughly researched. Obviously, you know your stuff, vastly informative. So I think this, I'm obviously not an expert in the area of transitional justice, but from what I have read, this is the most comprehensive study I've ever seen on this particular issue. I guess in terms of questions, my question is probably quite an open one, in the sense that I think in your narrative, you started bringing out a sense of something of a central argumentative thread in your argument. And I know that it's often difficult at early-ish stages of your research to tie that all in together, but wondering if you might be able to speak a little bit more on what you think that central argument might be.
Mm-hmm.
Okay. If I can just jump in with a sort of a follow-up on Mara's point. One thing is you can also think about the unintended consequences of regulation, right? So you're proposing to regulate the activities of these private actors. You might end up finding that that'll open the door to actors, particularly certain countries that may not be particularly happy about this kind of private engagement of these processes, where you end up actually constraining these private actors and limiting their positive effect on transitional justice processes.
Yes, exactly. I'm speaking about that in my paper, but maybe too briefly to grasp the problematic of this. And I also say, to touch upon your last point, is that yeah, they will probably be reluctant to actually support further these mechanisms if we establish some rigorous regulations in this field. But coming back to the question about the concerns, so far I haven't found any evidence of the bad influence of such assistance or embeddedness of philanthropic foundations or the private sector in general. Also, private sector is another thing. I will speak about it on another occasion. But coming back to philanthropic foundations, of course, you know, nobody suspects them, because philanthropic foundations, their main goal is to bring good to the people. And so far, I haven't found anything. But doing this research is not an easy task for me, because even looking for the examples, I barely could find anything, because these examples are not, you know, not accessible like on the internet. I had to go through the annual reports, finding out who donated what, who recruited whose staff members. So I played a bit of an investigator in this job. So of course, I mean, finding these hidden motives or hidden distortions is a challenge for me. And I don't say that I will ever find them, actually, because this is so hidden in this political processes, in this even in the hidden in internal processes, and I don't have access to this. So, but the main thing is that I think that letting the private sector or letting private actors to operate such things as transitional justice is already per se something disturbing. That's why we have to look closer in this enterprise. And as I said, it's the part of my PhD project, and I just started some months ago. So by the end of my PhD, I will probably will be able to articulate these concerns and these risks in a better way. But for now, I would say it's just my gut feeling that this is there is something wrong in it.
Super, Julia, you're smack bang right on time. So wonderful. So our next presenter is Mara Rivkin, who is, Dr. Mara Rivkin is a legal scholar and political scientist who specializes in empirical research on armed conflicts and peace building, and she is currently the National Security Law Fellow at Georgetown Law. Her PhD dissertation examined the Islamic State's legal system, and she's conducted considerable research with UN agencies in Iraq on various issues such as police reform, transitional justice, and the reintegration of individuals perceived to have been associated with Islamic State. So Mara, over to you.
Thank you so much, Professor Halal. And I have slides that I'd like to share. If you can just bear with me a moment while I am sharing these. And okay, great. Great. Can everyone see the slides? Great. Thank you so much to ASIL and for the opportunity to be here. I'm presenting a paper entitled Insurgent Legality, and this is about how insurgent groups in civil wars use legal systems to help establish control over territory and build local support, and it's based on empirical research and evidence from the case of the Islamic State. I want to start out by emphasizing first the human dimensions of this research, because I think it's really important for scholars of international law to keep in mind that the armed conflicts that we are lucky to be able to study from a safe distance are an inescapable reality for populations that we write about in papers like this. So I just want to briefly show you these few images that I hope provide a very small window into the experiences of Iraqis who lived through the Islamic State's very, very harsh rule in Mosul, followed by what has been described as the deadliest urban combat since World War II. These are drawings by Iraqi children who fled Mosul in 2017 during the battle and were living in nearby IDP camps where I was doing field research at the time. And on the left, we see civilians being killed by an airstrike, and on the right, Islamic State members are shown executing 2 prisoners. One is being shot by a firing squad, and the other is being drowned alive in a cage. And these are really difficult images to look at, but I think they're an important reminder of how devastating this conflict has been for Iraqis, whose perspectives are really at the center of this paper and of my broader research agenda. Sorry. Okay. So I want to start out by emphasizing, So moving now to the topic of the paper, some insurgent groups engage primarily in warfare and looting, but around a third of contemporary insurgent groups seek to govern people and territory for both ideological and strategic reasons. Although the Islamic State is best known for its extreme violence against civilians, it also operated institutions, including courts, police, and hospitals, that provided some degree of security and basic services to the population in an attempt to build legitimacy. The Islamic State's rapid capture of territory in Iraq and Syria in 2014 was driven by long-standing historical grievances. So first, Syrians and Iraqis had experienced many forms of state-perpetrated injustice, including unfair trials or arbitrary detention without any trial at all, as well as torture and other serious human rights violations. And second, both states were very corrupt and failing to provide their citizens with basic infrastructure, services, and job opportunities. And third, both countries had experienced Western colonial intervention and occupation, and one of the Islamic State's objectives was to recapture lands that it claimed were wrongly stolen from Muslims. The Islamic State exploited these grievances to build local support by promising to deliver good governance and rule of law in a utopian Islamic society. And I'll just give one example from the group's early propaganda here. The people are as equal as the teeth of a comb, and there is no difference between the strong and the weak, and the grievance of an injured party will be redressed. So even though the Islamic State ultimately failed to fulfill these promises, they initially had some resonance with Iraqis and Syrians who were frustrated with injustice, economic inequality, and corruption. After capturing major cities in Syria and Iraq in 2014, the Islamic State announced its establishment of a caliphate purportedly based on the original 7th century model of Islamic governance. This caliphate was to be governed by the divine body of Islamic law known as Sharia, which the Islamic State considers to be the only legitimate source of law. And while it was building its own state, the group also wanted to destroy what it viewed as artificial man-made states and their man-made laws and borders, as shown here in a video of Islamic State fighters using a bulldozer to symbolically erase the physical boundary between Iraq and Syria. So at the height of its expansion in 2014, IS controlled 34,000 square miles of territory with a population of around 10 million people. And as it captured territory, it also started engaging in governance, including with courts, schools, and education. And made changes to these institutions by introducing new laws and educational curricula that served its particular ideological purposes. In the theory I advance in the paper, I argue that an insurgent group's ability to establish and consistently enforce its own internal legal system is a necessary condition for its successful control and governance of territory. In successful state-building projects, the emerging state generally establishes legal institutions before it imposes other more extractive policies like taxation and military conscription. And this is a way of establishing a kind of social contract with the population. This is a pattern observed not only in cases of rebel governance, but also in the formation of early nation states in medieval Europe. However, I argue that if an insurgent group's legal system is flawed by procedural injustice, corruption, and arbitrary violence, it will lose local support and likely collapse as a result. I'll now present evidence for this theory from quantitative and qualitative data that I've collected on the case of the Islamic State. I built a data set that maps the activities of the Islamic State's governing institutions across time and space in all 21 Syrian districts that the group governed between 2014 and 2017. It's based on more than 2,000 Arabic primary sources, including local newspapers, internal Islamic State documents, and social media data. And here's just a snapshot of what the data set looks like, and with each letter representing a particular institution. You can see on the upper left, there's a P, which stands for police, and this indicates that in Raqqa, the first institution established by the Islamic State was a police force in July of 2013. And here's an example of a primary source from the data set, which is a photograph of a utility bill issued by the Islamic State for drinking water in Iraq. And here is a post by a Twitter user reporting that the Islamic State had begun collecting taxes from cattle farmers in Syria. My data also includes a survey of more than 1,400 residents of the Iraqi city of Mosul, which was the Islamic State's former capital, and in-depth interviews with more than 300 Syrians and Iraqis who experienced the Islamic State's rule. The data shows that the Islamic State generally established legal institutions, courts and police, before it imposed other more extractive and unpopular policies like taxation, and before it began forcibly conscripting civilians into its military. One of the first things that the Islamic State did after capturing new territory was to issue a constitution-like document that it called a Charter of the City, shown here on the slide, with 13 articles that promised to provide the population with services, protection, and some basic rights in exchange for their compliance with its laws. And I argue that this was a kind of social contract. And at least initially, the Islamic State system of governance was perceived by some civilians as relatively more efficient and less corrupt than the Syrian and Iraqi states. So in the survey I conducted in Mosul, for example, 39% of respondents perceived an improvement in the cleanliness of Mosul streets, and 38% perceived a decrease in the amount of crime after IS captured the city in comparison with the previous period of Iraqi government rule. However, over time, let's see, the Islamic State's legal system became increasingly corrupt and violent, which then undermined the group's legitimacy, contributing to its eventual collapse. When the Islamic State first captured cities and imposed its strict laws, including bans on cigarettes, music, and other activities that it considered un-Islamic, enforcement was initially lenient while the population learned and adjusted to these new rules. But over time, punishments became increasingly harsh and arbitrary, and by 2015, cigarette sellers who would have been let off with a warning in the early days of IS rule were being thrown into prison and publicly beaten. And while IS was becoming increasingly authoritarian towards civilians, it was also starting to lose control over its own members. In the early stages of its rule, the group did manage to maintain some degree of internal discipline and was known for punishing its own members if they were caught committing crimes against civilians or other abuses of power, such as theft and smuggling of illegal goods. But over time, reports of corruption and misconduct by IS's own members and fighters became more common, and they were also much less likely to be punished. So I argue that as the leadership became increasingly preoccupied with fighting what was obviously going to be a losing battle against a massive international military coalition, they didn't have time to monitor or punish misconduct within their own ranks. And at the same time, the Islamic State was losing increasing taxes, forcibly conscripting civilians to replace the fighters it was losing in casualties. And it was also losing the ability to provide critical services and infrastructure as its institutions were destroyed by airstrikes. So I'm going just wrapping up now because we're short on time. Civilian resistance started to increase, both violent and peaceful. There were assassinations of Islamic State leaders as well as peaceful protests. Here is a photo of women protesting outside of an Islamic State court in Syria over the arbitrary detention of their sons. So in conclusion, IS's legal system was initially perceived as relatively fair, although harsh, and this helped IS gain control of territory and build local support. But as the Islamic State lost its ability to maintain law and order, and its members increasingly violated their own rules with impunity, the legitimacy of its rule collapsed as it became clear to Iraqi and Syrian civilians that this group had failed to fulfill its original promises of justice and security. I'll stop there. Thanks so much.
Thank you, Mara. This is just fabulous, and it's and just clearly the Herculean effort in undertaking the quantitative and qualitative aspects of the research is really quite impressive. And I mean, just the personal engagement and conducting these interviews on the ground, really something to really wonderful, and congratulations on such an impressive project. So I have sort of three questions, the first two of which are sort of on the account, sort of almost the factual account that you present. So I'm going to use sort of the main claim that you make in the paper, and you put it up there on one of your slides, and I have here on page 9, where you say the following, quote, "A group's ability to clearly articulate and consistently enforce its own internal legal system as a de facto state is a necessary condition for its successful control and governance of people and territory." So basically, there seems that there are two main elements here: clearly articulate and consistently enforce. Now, from the account that you've presented, it appears that the initial surge in popularity of IS, or at least its perceived legitimacy, was related to the fact that it was not consistently enforcing its so-called clearly articulated body of laws and norms. In fact, if anything, it's only when they, or part of the breakdown of their legitimacy and popularity was that they started to consistently and effectively enforce their own stated norms. So I sort of, when I was reading, I felt that there was something of a mismatch here. You know, your original theoretical claim seemed to say that you've got to articulate a body of norms and enforce them, but actually the data that you seem to suggest here is that enforcing the norms robustly actually caused sort of basically people to start to reject the IS rules. So that's the first point. The second point, you're often using the terms law and order together, although it seems to me that really in the context of IS, those two things are not the same. And maybe the main source of IS, you know, quote unquote popularity or acceptance among the local population was first and foremost relating to just, you know, giving a sense or a semblance of order through effective physical control of the territory and providing these basic services, as opposed to law per se, as opposed to creating a set of, you know, a body of norms and a body of institutions that would enforce those norms. And so I was just, you know, I found myself thinking, is it the law? Is it the idea of, again, the way that you describe it, of articulating and enforcing an internal legal system? Or is it just about physical control and safety and these basic, you know, it's like Maslow's hierarchy of needs, where at the very basic level that IS for a while provided the resources necessary for just survival for people in those areas. My third point is at a more sort of theoretical level. Now, one of your core claims here is that once you start to have procedural injustice, an authority, sort of, you know, a governing authority begins to lose legitimacy, and ultimately that could contribute to its downfall. And when I read that, I found myself going back to all that political science literature about durable authoritarianism. And you point to Iraq and Syria. And I think one of the really remarkable things about Iraq and Syria, the Ba'ath regimes in Iraq and Syria, is despite the fact that you had decades of systematic and systemic procedural injustice, was that these authoritarian regimes actually were quite durable. And they managed to survive despite the fact that there was rampant procedural injustice. And so it makes me wonder about sort of the final part of your central claim about necessary conditions, right? You know, are there other necessary conditions, even in the case of ISIS? So for example, a legitimating narrative or justificatory narrative, this idea of Sunni versus Shiite, or, you know, the ideas of racial purity, or in other contexts, because, you know, at the very last sort of paragraph, you point to the US and, you know, other narratives such as racial superiority or racial purity. You can have, and I'm just thinking out loud here, right? Could you have a situation where you have procedural injustice that a body of an authoritative, a government basically continues to enjoy legitimacy because of other sources, other necessary conditions for their successful control of territory and people. So that's what I had. But wonderful, wonderful paper. Congratulations.
Maybe I'll collect questions and comments from everyone and respond to all together.
Absolutely, yeah. So Julia, Aaron, yeah, go ahead, Julia.
All right, Mara, congratulations. That's an amazing, fascinating project. There is a lot of work in it, so good luck with finishing it. I have one question and one maybe more of a suggestion. And the question is, can we actually discuss the legality of insurgent groups, or in this case, the Islamic State, without first analyzing the elements of the statehood, if Islamic State is a state in general? And I haven't seen it in your paper. Maybe it's not your focus, maybe it's not your argument, but for me, I was left with unsatisfaction, that I would love to hear your analysis on these 4 elements of the Montevideo Convention. So maybe if you want to deepen your legal analysis of the paper, not the discussion of your empirical studies, maybe add something about this as well. And more of a recommendation, if you want to do that, you might want to look at the discussion on the Republic of Pirates. Maybe you've heard of it. It's the Republic, I don't know how many centuries ago, in Nassau, and they called themselves the privateers. I'm not sure if I'm pronouncing it right, but they also perceived themselves as outsiders from the legal order. And back then it was the imperial legal order, and their actions actually shaped new jurisdictions, and they also had their own codes of conduct. They also had their institutions. They had different doctrines and procedures, even like something similar to trials. But they did not think of themselves as outsiders of the legal order. Instead, they created their own legal order to protect themselves from the prosecutions from the outside world. So maybe this discussion will help you. I think there is a lot of literature written on this because it was so many years ago. You can maybe draw some inspirations from this.
Thank you so much.
I also have one comment and one question. But firstly, I have to say I absolutely loved this paper. I love the project. I think you have an amazingly detailed data set here, and it's written obviously on very topical and important issues. It's interesting to see that even though the subject matter is quite different from my own work, there are certainly some resonances there. I mean, in the broader sense, I kind of see it almost as how law is produced from the outside and how it makes its way into the mainstream in any given state. So in other words, the creation of formal law and how does that kind of happen? So that's a broad issue, broad set of issues that I'm very, very interested in. I guess by way of a question, I was just wondering if you could possibly say a bit more about how you went about gathering this data. I saw that you've conducted more than 200 interviews, which is just amazing. So how did you manage to find your interviewees? Because I can't imagine that would have been an easy task.
Thank you so much, everyone. So I see we only have a minute left, and I can't respond to everything, but I'm going to take all of these into account. They're so helpful. Just to respond, I guess, very briefly to Professor Halal's initial point on whether to what extent the IS was actually enforcing laws consistently in the beginning. I think I didn't do a great job of conveying this in the paper and need to be more clear. What happened really was sort of a honeymoon period where the Islamic State kind of announced its rules and gave the population time to learn them. And at this time, it's also using its police and courts in kind of an educational function, sort of having public court hearings and announcing and publishing rules and paper around cities. And it was after this initial sort of period of adjustment that they did start applying rules consistently. I think what happened and what I see as the real decline of legitimacy was increasingly arbitrary punishments and really kind of inconsistency in punishments, where punishments were increasingly disproportionate to the crime committed and inconsistent with IS's own rules. And then in terms of necessary conditions, I think you're absolutely right that that I need to be more clear in the paper. In addition to the erosion of its legal legitimacy, a huge factor in the Islamic State's collapse was external military intervention, which destroyed its institutions and made it more difficult to govern and provide security. On the security point, yes. In terms of IS's ability to build, okay, sorry, we're out of time now, so I'm going to discuss this. I'll follow up with you later, Professor Halal, but really, really appreciate everyone's comments and suggestions. Thanks.
Thank you, Mara. That's fabulous. All right, so our third speaker is Aaron Wu, who is currently a legal advisor for the UK government, where he focuses primarily on public international law and international economic law and environmental law. And he's also worked for the Australian government, and he's also taught at SOAS and the LSE. There's more to say about Aaron, but I think it's more important to hear from him and from his wonderful project titled Sustaining International Law History, Nature, and the Politics of Global Ordering. So Aaron, go ahead.
Thank you, Professor Halal, for that extremely generous introduction. I must say at the outset, I'm very grateful to have been selected for this panel, and it's a pleasure to speak with such an amazing group of panelists today. So my paper, in short, tries to answer a set of interconnected questions. They are, what role is international law actually playing with regard to the environment? What ideas, what values, and what preferences about the environment are being sustained through law? And how has the law come to be framed in this particular way? My starting point is the premise that we cannot truly think of the environment in any kind of neutral way. It comes with a lot of conceptual baggage because it's enmeshed within constellations of power and knowledge that have given it its shape and form. But what does that conceptual baggage look like? Well, I feel we tend to frame the environment in three, perhaps fraught ways. Firstly, we tend to imagine it as something compartmentalized. That is to say, something separate from the idea of human society. By contrast, we know from scholars like Donna Haraway, for example, that humanity and what we might call nature are actually entangled in infinitely complex ways. In other words, society and nature can't be cleanly divorced from one another. Yet, it's this categorization that has led to the formation of hierarchies, and these hierarchies form a basis for some of the inequalities we see in the world, not only between species, but also within the category of the human itself. The second way we tend to imagine the environment is as something static, meaning that we tend to see it as something timeless, unchanging, and immutable. But in reality, we know that the environment, if it's even correct to see it or call it in that way as a type of homogeneous entity, is actually something dynamic and constantly changing. For example, no ecosystem is ever perfectly identical from one moment to the next. And the third way I feel that we tend to imagine the environment is as something ahistorical. So to put it in another way, the environment has a complex and often very contested background, but this isn't typically reflected in contemporary scholarship. And as such, we often don't completely grapple with the context or the contingencies that gave rise to environmental issues in the first place. Now, I feel all of this leads itself to a slightly difficult truth. That is, the results of our efforts to tackle environmental problems have, in many ways, been relatively disappointing. On basically every metric that we have, the state of the global environment is much worse than it was when we first started negotiating the big multilateral agreements 50 years ago. All the while, we now have almost 4,000 international legal instruments that address environmental issues directly. That is according to the University of Oregon's IEA database project. Alongside that, we have a wealth of exceptional scholarship that focuses on how to improve legal techniques for remediating environmental harms. We might see this in works that try to expand such areas as regulatory coverage, litigation, transparency, enforcement and implementation, or environmental impact assessments. This work is extremely important, but it doesn't concern itself with how international law could actually be part of the problem rather than just the solution, or the discipline's complicity in the root causes of the very environmental and social problems that it tries to resolve. All of this compels a need for more work to understand why and how international law may in fact resist policies that could indeed serve us better. To answer this, my book project tells a story about a story. It draws attention to life's complex diversity, its contingency, and its dynamism. And with this, I tell a history that tries to bring out and better harness what I call law's critical potential. The history is one that's anchored on events and inflection points scholars and practitioners might find familiar, but I tell that familiar story in an unfamiliar way. I feel that reviving these latent stories or stories that currently sit outside the boundaries of positive law could help us open new possibilities and help us to think more deeply about what might be achievable in the future. Fundamentally, international law is a discipline with apparently global scope and applicability. So it's uniquely positioned to enact and enliven these alternative stories. And perhaps by doing that, start to reverse its own structural biases. In that sense, I'm deeply inspired by the work of post-colonial and critical legal scholars such as Susan Marks, Stephen Humphreys, Sandhya Pahuja, Marty Koskiniemi, as well as the late and very dearly missed Peter Fitzpatrick, to name but a few. In piecing together my counter story in the way I have, I've also focused on the idea of dissensus. More specifically, how challenges to the status quo might themselves become redirected in ways that actually reinforce that status quo, as well as the inequalities produced by it. To that end, my story shows how international law both sustains and is also sustained by certain stories about nature and the environment. Last but not least, I think it's important to note that this isn't just an intellectual inquiry, because I truly believe the fate of a lot depends on answering these questions in a forthright and self-reflective manner. And to that extent, I'm extremely grateful to all of you for reading my paper, and I look forward to any comments you might have.
Thank you, Aaron. This was definitely a delight to read. It is exquisitely written. It really does fire up the imagination. So I have sort of two sets of comments that I've sort of divided into sort of tactical comments about writing an introduction to a book and sort of broader theoretical comments. So first, I felt that this chapter or the introduction reads less as an introduction of your thoughts and more as a literature review. And I found myself, you know, turning the page. It's beautifully written, but then I was like, I felt myself looking for Aaron's voice as opposed to sort of a catalog of sort of a summary of the views of some of these outstanding scholars. But I would have appreciated if you would sort of bring in your voice much earlier, and then maybe later on sort of highlight how your approach and your thinking differs from those of others who have written about the same thing. So that's sort of my structural slash kind of a way of sort of pitching an introduction to the book kind of comment. My second comment is maybe more substantive in nature, and it sort of relates, and I see this in so much writing, and I have to be honest, it always makes me a little bit uneasy. We sort of attribute agency to international law as though it is some kind of living creature. So, you know, for example, you say that, you know, it's like international law does something, or that it actually has the ability. So to me, international law is an inanimate object. There are actors, there's individuals, scholars, students, states, institutions, NGOs, those, and it's the process of, you know, it's the action and counteraction of those actors and how they use international law. But just as a reader, I always, you know, for example, you say international law is capable of initiating new categories, classifying things, and people determining the. I don't think international law is talking about international law. And then at a certain broader level, and here I'm sort of dealing with the periodization that you propose at the closing part of the chapter. And here's what I found myself thinking. Actually, I see that, you know, you're critical of this sort of move, the environmentalism, let's say, of the past 50 odd years. But my thinking is, there's been so much progress. I mean, it seems to me, just from reading the couple of pages at the end of your chapter, that we went from a time where we thought of the environment as simply a set of natural resources that are out there to be exploited. And then gradually, the concept and term, the environment, started to be recognized as an entity that deserves, you know, active engagement, that deserves to be protected. And then we moved sustainability. So I'm wondering, it's almost like I'm offering a critique of the critique. It is, you know, is there nothing good to show? I mean, 100 years ago, it was probably unthinkable to talk about sustainability. The whole idea of environmental protection and none of this was around. And just in the chunks, you sort of your first chunk of time is like a good 400 years where nature is just out there for us to exploit and expropriate. And then very quickly, in about 70 years, there's a transformation there. And I thought it would be really interesting to tell us how and why that transformation came about. It definitely has politics of exclusion, but there must have been something good about it. And I speak here as somebody from the third world, where, you know, there's one line where you mention, and this opened the door for African states to build these mega projects and dams. In many ways, that's also a success story for many third world countries, and they view this as almost part of their self-determination, right? So there was that aspect. And then finally, your very last line was sort of, I thought this was to me, that's what I was looking for, where you You cite Frederick Engels and you tell us that deconstruction alone is fine, right? It's okay to provide a diagnostic picture without talking about a constructive kind of an actual policy proposal. And to me, that would have been just really fabulous to hear your thoughts and to hear your ideas. Well, how is it that the dislocations and exclusions that have been generated because of the way we've dealt with the environment, how could we remedy that? Right? I realize that deconstruction is perfectly legitimate scholarship in and of itself, but I've always, reading critical legal studies, for years, I've always found myself, well, what do we do about it? Right? And it's always been really frustrating to just sort of tell us why it's wrong and what all the unintended consequences and dislocations are, but then just stopping there. So it's almost sort of inviting you to be more sort of adventurous and, go beyond the deconstruction. Thank you. Yeah, I don't know if Mara and Julia, if you've got thoughts.
Oh, thank you so much, Erin. This was really fascinating to read, and I'm really interested in the idea of sort of using storytelling and truth-telling as ways as a mechanism for achieving justice. And it's particularly interesting in the context of your case of the environment and nature, because that's an area where if we think of nature as the victim, it doesn't actually have its own voice, and so there's always going to be other people. The story is inherently going to be told by other people. So I was interested and sort of surprised when you wrote toward the end that that this isn't a normative project and you're not trying to sort of dictate a particular normative outcome. And I was surprised by that, because it seems to me kind of an inherently normative project if you are taking a position that the sort of existing ways in which international law has evolved or developed around nature and the environment is wrong, and it needs to be and you do seem to be writing this from a place of wanting greater environmental protection. So I was just curious if you could say more about why you don't consider this project to be normative.
Aaron, thank you so much for sharing your paper, and the best of luck with the book project. So I won't focus on questions, just a suggestion maybe. So I think it also linked to what Mara just said about the normativity of your project, that you're claiming that it's not actually a normative project, but in your presentation today, you said that you will use positive law to actually assess these things. And I would suggest that if you're going to assess the positive law in a storytelling context, I would suggest you to look at the history of international norm creation. For instance, like what Hugo Grosz just said. I recently read a paper when he was talking about the socium of the society, where he included animals in the notion of society. And then he elaborated, why are we only focusing on humans if animals are also part of our bigger environment? So I can share with you privately the links and the sources, and yeah, good luck.
Well, thank you to all of you for those lovely comments. Wow, I'm a little bit floored by the generosity of them. So perhaps the best way I may be able to do this is just quickly to say that, Mohammed, absolutely take your comments on board. Bring in my voice much earlier, and I think that's something that I will try to do in the rewrite of this introductory chapter. The other things that I mean, I think I saw a common theme between your question and Mara's question about not being normative. Well, I guess so. This is the thing about CLS. I've always felt that critical legal studies is about emphasizing our understanding about the world, essentially. And insofar as we can tell a story that gives added richness to that understanding, I feel that it's something that's worth doing, not only in terms of the environment, but also in terms of transitional justice or in terms of state building. I guess in my project, I was slightly hesitant to be normative, explicitly normative, that is, because I felt that to do so would have essentially tried to make what is a non-metaphysical project and shoehorn that into some kind of metaphysical structure. However, having said that, as part of my story, in bringing out sort of these latent stories, I've tried to bring out what stories have not been kind of taken seriously or been subjugated in a particular way, and implicitly I've shed light on things that might actually serve us better. So in that sense, the normative and the analytical actually combine, but I haven't tried to make the normative explicit. I've made it more kind of implicit. And to that extent, I know we're running out of time, but my inspiration for that is actually from post-colonial literature, and in particular, a genre of literature called magical realism, which you might be familiar with. Magical realist writers tend to use this type of approach, or dare I say, if you want to call it that, a methodology, in order to try and give a critique, but also point the way to a possibly what we might call a better future. But thank you for your extremely kind comments.
Well, Aaron, I think that was a spectacular way to close our session today. Our hopes for a magical realism, for our hopes for a better future for everyone. Thank you all so much for your papers, for your hard work. Yulia, who I should have mentioned, is an international lawyer from Kyrgyzstan, currently doing her PhD at Max Planck. And Dr. Mara Rivkin and Aaron Wu. Thank you all so much for your work, and thank you so much, ASOL, for bringing us together today. And just as an invitation, keep sharing your work. I'm available. Send me future drafts. I'd be glad to read and send you back some comments. But because this is, I think, the best part about ASOL, building this community of scholars to be able to engage with each other's ideas. So thank you so much, everyone, and hope you enjoyed our panel. Thank you.
Thank you.
Thanks so much, everyone.